Here we have Professor Eric Franks. We are going to continue our study about this tension between zonal governance and global governance. So this time with Professor Frank focused on the marine environmental protection. He's one of the best professors, experts in marine environmental protection. So he has studies in Belgium and in Georgia, but he's professor in the Free University Brussels in Belgium. He's a member of the Permanent Court of Arbitration, appointed by Belgium, so as he's actually director of the Center for International Law, president of the Department of International and European Law in this Free University Brussels, and he's member of several organs and specialized institutions. He's expert in marine scientific research for use in special arbitration under the United Nations Convention of the Law of the Sea. He's legal expert in the advisory body of experts of the Law of the Sea of the International Intergovernmental Oceanographic Commission of the United Nations, UNESCO, and he's expert in maritime boundary delimitation to the International Hydrographic Organization. So he has many titles that show he's a big expert, well known in Europe and at the international level. So please, I give you the floor. We have to hear you. We want to hear your study, your analysis of the marine environmental protection, this tension between zonal governance and global governance. Eric Franks, whenever you want.
Before starting my talk, which has been very influential on my interest, on stimulating my interest for the law of the sea. And that was a person who was part of the American delegation of the law of the sea, Professor Louis Sohn, and who is very much the conceiver of Part 15, at least as we know it today, with all the different opportunities as was explained to us yesterday. I was a student at the University of Georgia in the United States at the time that Louis Sohn was teaching there. And I always will remember the day, that was the academic year 1982-1983, and I always will remember the day that he came into the room, the classroom, very, very happy with a big smile, and a document in his hand, and the document which he had in his hand was the International Legal Materials, which at that time contained a publication of the United Nations Convention on the Law of the Sea. So he was so happy that it finally was there and that his classroom now had a text, a real legal text to discuss. But today, as you will see, I was asked to talk to you about the tension which exists between global and zonal approaches, not with respect to fisheries, but with respect to the protection of the marine environment. And that is what I will try to do. I will do it in 4 parts. First of all, I will try to fit my part in the panel of today. Secondly, I will say a few words about the 1982 Convention at 30, because at least that's what we are celebrating during this conference. Then I will turn to the issue allocated to me, marine protection of the environment. This is a very broad topic, and of course, I always respond to the topics which are attributed to me, but each speaker still has the possibility, of course, within each topic to specialize. And I will specialize on vessel source pollution, which is certainly, if you look at treaty law, the law which has been developed most, even though it's not, I recognize immediately, it's not the most important source of ocean pollution. It will be, first of all, zonal governance, secondly, global governance that I will address, and then finally, conclusions. And all this, I hope, in 20 minutes. What is the broader framework? Well, this tension between zonal and regional approaches is not typical for environmental protection. It also exists with respect to fisheries, with respect to the problem of illegal acts at sea. But I think that environmental protection stands out in a certain way because that part of the convention is really novatory. Of course, you can say that parts of the law of the living resources is also very new because the exclusive economic zone was created, and it's quite true. But if you look a little bit further and you look at the high seas, you will see that the relation between the fishing within and without that zone, the EEZ, is a part which the Convention does not really touch upon very substantially. Illegal acts at sea, I'm running a little bit ahead, but I think that the most important developments there are of a recent nature which come after the Convention, except for piracy, which is of course a very old issue at international law. And then also the concepts incorporated in Part 12, which is a part of the Convention dealing with the preservation of the marine environment. These have also been applied to other fields, and I would like to single out port state jurisdiction. My predecessors talked about port state jurisdiction as a possible new development in the law of fisheries, but of course this was not included in the 1982 Convention, but it was included with respect to marine pollution. So we see that marine pollution apparently is an area of international law where developments take place at a very early stage and are then also taken over to other areas within the Convention. The Convention at 30, why is it so important? Well, I think that we saw that yesterday. It was important at the day that it was signed, because it was the first time in history that so many countries at one and the same moment signed the document. The ratification, we also saw yesterday, had its difficulties in the beginning, and maybe the translators did not got all the names, but I only heard 3 European countries in 1994 which were part. There was also Germany. I don't know whether this was mentioned, but Germany was part, and of course this is a very important maritime country, but the only reason that Germany had ratified the convention before its entry into force was of course that they wanted to have the tribunal, the seat of the tribunal, and if they wouldn't have become a party at that time, probably the seat now would have been somewhere else. So it was certainly not out of interest that they became a party in 1994. But then it started changing. 2001, you see there is a nice spread. And of course, if you look at today, this is a very broad number. It is not the most ratified convention. Certainly there are others. And I would like to single out one, and that is the Convention of 1961, which was already mentioned, on diplomatic relations, immunities. The reason why is that, of course, you have 187 states which today are party to this convention, which is still a little bit more. And if you then realize that you have 193 states in the United Nations, you see that that is almost a complete picture, almost universality. With respect to the Convention on the Law of the Sea, we are not there yet. But you have to remember, as it was also stressed, that there are 48 countries which are landlocked. And of course, if you join the Convention on Diplomatic Protection, it's a take and give. You protect your diplomats on your own soil, and of course your own diplomats will be protected somewhere else. So it's a take and give. With respect to the Convention, if you are a landlocked country, certainly you have some rights within the Convention, but they are very limited. And it means that not all the interests of countries are similar. So for that reason, I think we can indeed say that it reaches or approaches the level of universality. And it's sufficient to look at the statements of the Secretary General in 1998, at the time that we had the Decade of the Oceans, or the International Year of the Oceans better. He stated that it was moving in the right direction. If you look at his statements a little bit later on, he started stressing that most of the coastal states were party to the convention. 2000, he said that it was nearing also the universality. And of course, if you look at his remarks at the occasion 4 days ago, or 5 days ago, at the 30th anniversary celebrated in New York, he stated that, yes, we are coming there, and he really urged a few countries who are not yet party to become so. We call it the Constitution of the Oceans. It has already been mentioned a few times, but constitutions can come in different forms and sizes and shapes. They can be either rigid or flexible. And if we look at the Constitution of the United Nations, of course, this is a document of 1776 better. There have been a few amendments, but the basic document is still the same. If you look at the Constitution of my own country, Belgium, we are only a country which exists since 1830. And this constitution has already changed so many times that you lose track of the different changes, meaning that a constitution can be a very rigid document or it can be flexible. And if we look at the constitution, I think of the oceans, there can be no doubt that this is a flexible constitution because it has already been changed quite a few times. Again, the remarks of the Secretary General at the 30th anniversary, he stated that certainly this codification, it is progressive development, but most of all, it is what he called a flexible and evolving international legal framework, of which, of course, the Convention forms the backbone. New developments, as I said, before the Convention entered into force, the Convention on the Law of the Sea, you had already a, it's not called a amendment, it's called an implementation agreement, but nevertheless it was already mentioned that as to the reality, it is really an amendment. And the same goes for the Convention of 1995. So there are a few, people have already spoken about maybe new supplementing agreements or implementation agreements. So it means, yes, it is a flexible document, and so this also, I think, applies to the protection of the marine environment, because there the Convention has shown that it has the capacity, I think, to adapt. Let's then turn to part 12 of the Convention. As I said, this is a very novatory part of the Convention on the Law of the Sea. Unlike other related fields of international law, it's mainly governed by treaty law. Treaty law, which normally works on the basis of, very often, action-reaction pattern. It means you have to wait until, and as I said, I will focus on vessel source pollution, it's a good example. You have to wait until something happens, and then you have a reaction. The first major oil spill was in 1978, or 1967 better, the Torrey Canyon, when it broke down. We had to wait a few years before we had the Intervention Convention, which followed it. If you see the Amoco Cadiz in 1978, it took a few years before the international community reacted by the Paris Memorandum of Port State Control. And if you look what happened in the United States with the Exxon Valdez in 1989, again, it was 1 year later that the United States, as already mentioned before today, enacted the Oil Pollution Act. So, yes, very often it's action-reaction, but the Convention on the Law of the Sea, Part 12, I think it was proactive, because it was the most developed environmental treaty which has been concluded or which had been concluded for many, many years before, if you look at the past, and it remained a very progressive document for many, many years afterwards. And I don't have to tell you that the negotiations taking place or that just finished in Doha are a good example on how difficult it is today to try to move in this field. Again, if we look at the report of the Secretary General in '89, when he had a special report on marine protection, he stated that this was a comprehensive statement of international law, the first one ever done, and he repeated that, or Argentina at least repeated that when it made its comments at the occasion of the 30th anniversary 5 days ago. Probably this is the part of the convention where the changes, when you compare it to what was before, have been the most impressive one. And again, vessel source pollution is a very good example of that, because if you look what happened before, it was rather simple. On the one hand, you had the flag state, and the flag state had almost total competence in the area. The flag state and the port state had very little. The flag state had some competences in the territorial sea, but was very much hindered by the innocent passage regime. And the port state at that time did not really have any kind of powers in this respect. After the 1982 convention, this whole system changed. Of course, the flag state is still there, but the flag state today is no longer the depository of all the rights and competences with respect to protection of the marine environment with respect to vessel source pollution. You also have coastal states which have received competences in their EEZ, and more than that, you have now the port state, which has become a very useful tool in trying to be more responsive in this area of international law. Again, it's not immutable, as demonstrated. It represents a balanced truck in, at that time, means 1982. And the question can be asked, of course, is it still very up to date? Nevertheless, it's a comprehensive approach where environmental protection on the one hand and shipping had been considered as two sides of the same medal. It means that you have to take both into consideration when starting to make rules. This is very much understood by IMO today, and consequently, I think also, especially in the field of environmental protection, the rules which are adopted on the international level have a certain precedence over the rules adopted on the national level. Very important and also very novatory in the convention are what is called GEARS, the generally accepted international rules and standards, which has been called an umbrella technique. And again, if you look at the comments of Greece during the 30th anniversary celebration, they stated that, and they remarked again, that this has been a very useful development. Why is it so useful? Because the 1982 convention, as is said, has a nearly universal participation. In that convention, you find what is called a rule of reference. You find these GEARS, these rules which say that you have to respect generally accepted international rules and standards. These rules and standards themselves are not to be found in the document, the 1982 convention, but they are found in other instruments, very often in conventions elaborated within the framework of IMO. And the result of this is that you can set up an argument arguing that the consent here is not given in the last step. It means not by becoming a party to the treaty which contains the rule, but the consent is given by becoming a party to the 1982 convention, because then you accept the rule of reference, and the rule of reference makes, of course, reference to the convention where the treaty norm is incorporated. So this is a very new technique which softens a little bit this very difficult element of consent on which international law today, unfortunately, is still very much based. Let's then come to zonal governments. It's a rather complex subject, and I'm not going to go in much detail, but there are many variables that you have to take into consideration. And the first one is that there is prescriptive jurisdiction, and the convention makes a distinction with enforcement jurisdiction, and also what to do if something goes wrong. It means implementation of responsibility and liability. Secondly, you have to make a distinction between types of measures that the coastal states or the port states or the flag states can take. They are, on the first hand, and that were the oldest one, discharge standards. It means that they try to diminish the pollution that ships deliver at sea, either accidental when they break up, but even more important because it is more, contributes more to the pollution, overall pollution of the oceans. That is the operational pollution. It means ballasting of water and also the normal runoff of oil when ships are in operation. Secondly, you have CEDM standards. Here, the responsibility is no longer with the captain of the ship, but the responsibility is with the owner of the ship, because very often when accidents happen, they are attributed to the M in CEDM, and that's the manning. It means very often there is a human failure when accidents do occur, and so also their standards need to be taken. And finally, you have navigational requirements like double hull, like navigational separation schemes that ships have to follow. And again, we are here with the responsibility of the captain. And then you have to make a further distinction between the zones in which you are located, and also the kind of competence, whether it appears to the flag state, the coastal state, or the port state. The zones are very important because in some zones you have competences, in others you don't. Like in the contiguous zone, there is no environmental protection possibility. And then finally, you also have to make distinction between where the violation occurs, where the vessel is located, and where the results are felt. And so all these elements have to be put in a mix, which then finally give you a result. And finally, that gives then the competence of the coastal state. And this competence, once again, is divided. Either you can institute physical inspection, you can institute further inspection, institute proceedings, or detain vessels. All this gives then very complicated pictures. If you look at Article 211 of the Convention, if you try to put it schematically, it takes you quite ingenuity, I think, to try to fit it in one single slide of a PowerPoint presentation, because there are so many variables that you have to take into consideration. This only covers the coastal state. If you do the same with the port state, it gives you another very complicated picture. Now, all this finally ends up to the fact that, yes, of course, the port state has been given new competences. Is it universal jurisdiction? I doubt, because it's still very much agreement-based. If you're not part of the agreement, it means it doesn't form part, as of yet, of customary international law, Article 218. And it's very complex, and it leaves out hypotheses, because, of course, when you start mixing all these things, something has to escape attention of the drafters of such a convention. And if you do it more generally, you will see that this whole setup of Article 211 with the differentiated approach of the coastal states also there, it's very nice that it's there, but in practice what we see is that coastal states are not very keen on going at sea and trying to inspect vessels. What they normally do is they simply wait until the vessel arrives at this port. Then how do we attach it to the global element? Well, global governance in the convention is treated very rudimentary. It was already mentioned, it's only a paragraph in the preamble and not much more. Is Article 123 giving us some further help? I'm afraid it does not. Some people are of the opinion that 123, when you're talking about semi-enclosed seas and about enclosed seas, that it gives an obligation for states to cooperate. I just came back from a conference in Vietnam, where, of course, countries very much want this to be there, because then they can at least urge China to be a little bit more cooperative. But unfortunately, we're of the opinion that 123 is not the article to look for a legal basis of that. I think the convention has much more better articles to base your duty to cooperate, and I think 197 is the way to look for improving the situation. Flag state jurisdiction, you can say that it's also a globalizing effect, because by giving the main competence to the flag state, there will be uniform rules. But unfortunately, as we know, you also have something which is called a flag of convenience. Practice, finally, you see that how do we try to promote this global aspect. It is by area-based management tools, either within or without zones of national jurisdiction. And this also brings me to national policies, because also there we see that states started out by first having national legislation on the territorial sea, then on the continental shelf as the zone develops, and then on the EEZ. Of course, when you do that piecemeal, a state ends up at the end by having a whole set of legislation where there is no interaction between the different departments. And we see that more and more since the 1990s, late 1990s, but more even in the 21st century, countries have tried to have what they call national ocean policies, which are integrated. Conclusion, I think the compromise reached during UNCLOS 3, I said 1982, but in fact, the compromise was already reached in 1974 by means of the informal single negotiating text with respect to Part 12 at least. You had still the incident in 1987, where France then wanted to have some kind of readjustment by giving a little bit more competence to the coastal state. But again, I would say that most of the essence of Part 12 was already decided very early on in the 1970s. So it means that the question can be raised, is this still up to date? We looked at it with respect to vessel source pollution with the International Law Association in 2000 and came to the conclusion that the instrument was flexible enough to be able to proceed as to the future. And as we said, also the flexible constitution needs to be taken into account. A turning point certainly has been unsaid, I think, 1992, and also the more recent developments, plus 20, where we see that this global approach has gained in importance. And that is also how international law today is developing. I think it's by means of these area-based tools that they are trying to further this field of international law. Also, national legislation is very important in trying to do that. And I conclude with saying that all this should be framed in the United or within the framework of the United Nations Convention on the Law of the Sea. I think, again, Canada stressed this convention is flexible enough to have this global governance approach within the convention developed. And I think if you look at the Secretary General's Ocean Compact, which he has proposed, also there you find indications that it is the way forward. And to conclude, my last words would be that this really ties back to how this whole negotiation process in 1973 started. Very early on, people agreed that it would be a package deal. It means that the whole convention would be tied, everything together, and this would be the way forward. I think today we again arrived, with respect to the protection of the marine environment, to a similar point of conjecture where states again realize that the zonal approach probably is not the final word, but that countries need to cooperate more closely over boundaries, over disciplines, in order to be able to look into the future. I thank you for your attention.